Morning, Mr. Black.
Good morning, Chief Justice. Good morning, Your Honors. My name is Attorney Alan Black from Springfield, representing Mr. Stewart in this matter. I'd like to start off with issue number 3, which is on page 38 of my brief. And it's the issue regarding what we allege to be error, and it was an objection in this case, allowing a statement of a witness named Miss Mendez the day after the incident, in which Miss Mendez testified after the incident that she was driving with the co-defendant in a car, the defendant not being in the vehicle, with a woman named Katie Robillard, that a car with Tony Vaughn and Russell Rose drove up. Tony Vaughn and Russell Rose were, for lack of a better phrase, enemies. Tony Vaughn was probably the intended, if you believe the theory of the case, the intended victim in this case. He was not obviously shot or killed, but he was probably the intended victim. He drove up to their car, asked by the Commonwealth if she could tell the jury what was said by Rose and Vaughn. There was an objection. This objection was overruled. They were asked to give an offer of proof, and the offer of proof was that Rose tells the co-defendant to tell his friend, presumably referring to the defendant, that he was a bad shot and that the wrong car was hit. Hendricks, the co-defendant, replies, okay. That was it. That was a conversation. That was allowed in. The Commonwealth argued that that statement goes to the issue of motive, state of mind. The court ruled that it was supportable under a joint venture theory. And it establishes that they knew each other, meaning the defendant and the co-defendant. Of course, there were about 8 other witnesses that testified to the relationship of the defendant and the co-defendant. That certainly was not necessary to prove that they knew each other. He gave an instruction, and the instruction basically said that I'll give you more information in detail, but this goes to establish a joint venture. And then he doesn't come back to this in detail. He does not instruct the jury as to how to deal with this in any form at the closing. This is all he says to the jury. First of all,
So
in light of the other evidence in this case, assuming that was error for a moment, okay, how is that prejudicial?
Well, this case, I don't even know where to start with this case, because this case has so many different issues in terms of what came in, what didn't come in. And I didn't know to start here, to go to the motion to sever first or second, but yes, there is some evidence related to the defendant. There are a couple people say that the defendant made some statements like after the fact, like I think one was, I got that nigger's girl, I believe that was one. Although, again, these were friends of the co-defendant who testified to that and didn't testify to that in the grand jury and were impeached on those statements.
I'm thinking more of him getting out of the car with a gun and shots being fired.
And Costa testified. She said she saw both men shooting.
It's
if
true.
You believe Costa. I mean, Costa isn't the best witness in the world, but you can't say there isn't testimony of an eyewitness. There may be testimony of an unreliable eyewitness.
I'm not sure if and correct me if I'm wrong, she testified, I think, at the grand jury that she actually got out of the car at some point and saw only the co-defendant shooting. But she specifically said only the co-defendant. Now, one witness says only the defendant gets out of the car with a gun. One witness says both get out of the car with a gun. One witness says they hear both people cocking guns before they go out. But then the co-defendant testifies that he had no idea what was going on. Only the defendant did the shooting. He had no gun, never had any gun, and blamed the whole thing on the defendant. And the co-defendant gets a not guilty. And there was no motion to sever filed by defense counsel.
Well, according to the Commonwealth's brief, and I'm looking at page 7, it says, she says that they got out of the car again.
There's no issue that they got out of the car.
Okay.
Everybody,
And that the shooting followed
and
very
that the
promptly
shooting
thereafter.
followed. There is no issue that they got out of the car.
Costa said she saw both men shooting, and the Commonwealth cites to volume 2, pages 400 to 401. Now, I haven't looked at that, but I assume that they have something to back up what they say. This is page 7 of the Commonwealth's brief, and it says Costa said she saw both men shooting, volume 2, pages 400 to 401.
And I have written down that only the Costa saw only the co-defendant do the
Okay,
shooting.
we'll have
but
to
I'm-
look at the transcript,
Well, we'll check it
obviously.
out, but
You'll check it out.
go into the motion to sever for a minute, which counsel didn't file. There was a motion for new trial in this case.
Yes.
Am I right?
Yes.
Did counsel testify at that, if I got the right case?
Yes.
And didn't he explain why he didn't file a motion to sever?
I don't believe he explained it adequately. I don't believe he
Well,
explained it at all.
let's- but
He admitted that he did not file a
But the
motion to
other defendant filed the motion to sever, and he said just before trial, when they were arguing the motion, that he joined in that motion. Is
Yes,
that correct? So
that's
then why
correct.
does he have to file a separate motion? Doesn't that happen all the time?
Well, actually, it doesn't happen all the time. At least it probably shouldn't happen all the time, and some judges actually don't allow us to do that. Sometimes I will say, can I join in? And then, no.
Let's
file your own motion.
assume for a moment he joined in it, and it thereby creates his own motion to sever. Did he give an explanation on explaining? Well, first of all, if that's true, he did file a motion to sever. So that takes away the point that he filed no motion to sever, correct?
What I put in my brief was that he did not file a written motion to sever. He orally joined in with co-defendant's motion. Therefore, you're correct. There is a motion to sever on the record. He filed it when the co-defendant argued his motion prior.
Okay, so, and the judge denied it, I guess.
The judge denied it. And then at some point in time during the trial, I think after opening arguments, when it was clear during opening arguments that the tenor of the opening argument of the co-defendant was to put the blame on the defendant, he called, there was an objection, they went sidebar, and he said, and I think I have the quote in here, he said, "You are now treading on dangerous ground, co-counsel. You are starting to place the blame on the defendant." And that conversation occurred. I think at some point in time when the co-defendant decided to testify, and the co-defendant clearly was saying, "Hey, I knew nothing," he
being the judge?
He being the
This defendant's counsel.
defense counsel then said, I'm moving now to sever because it's clearly a Moran-type issue. And then the co-defendant's, trial judge said, "I'm concerned about this, but I'm denying the motion."
All right.
That occurred during the trial.
So your argument really isn't that the defense counsel did anything wrong. It's more that the judge did something wrong.
Well, I have several issues on ineffective assistance of counsel in there, and I'm not gonna, I don't want to linger on that right now. But clearly, as to the motion to sever should have been allowed at some point, whether before, whether during, whether.
So you're saying the judge erred?
The judge erred several occasions in this case, and that's one of them. Allowing the statement of Ms. Mendez to testify to tell your buddy that this was a bad shot.
I know it, but we're talking the motion to sever, so.
The judge erred.
In your opinion, the judge erred.
It was clearly a Moran issue. It was clearly inconsistent defenses, clearly where the two of them were blaming each other. And it's not a situation where somebody else could have done it, because as we just noted, 2 people walked out of the car, not 3, not 4, not 5. And it was only when these 2 left, there were shots. One of the witnesses testified that they heard 2 different types of shots.
Does it make any difference between this case and Moran that there are a lot of eyewitnesses in this case, or some eyewitnesses?
I believe, I keep on saying there are no eyewitnesses. I know there's this Costa, but read that carefully. I think Costa testified that she got out of the car. They got out of the car once, they came back to the car, then they got out of the car again, and I think after they waited a while, she sort of got out of the car and might have seen something, but I don't think it was so clear. And I thought she said co-defendant did the shooting, and I think then her grand jury testimony was different than her testimony at the trial. So I don't think it was as clear as that, but I'm sorry,
Well, we go by the testimony at the trial.
At the trial.
Unless she was impeached in some way.
clearly.
And I think the point is, if in fact this is close to Moran, what about Sinnott and Cordero, which say even if the defenses are antagonistic or extremely antagonistic, that isn't the end of the analysis?
It's not the end of the analysis, clearly, and I agree that there has to be some kind of prejudice in this case. And I mean, I don't know how else to demonstrate prejudice other than to say the co-defendant got off. You know, it's clearly. I mean, I think it was clear that the co-defendant, because there was a statement that came in where 2 weeks before the co-defendant said, "Okay, you want to start a war? We're going to start a war," and that was introduced. So clearly, the co-defendant was involved in this case. One of the witnesses said the co-defendant had a gun. There were another witness that said both of them got out with guns. One witness said both of them, but the co-defendant got off. And how did the co-defendant get off? Well, the co-defendant blamed it on the defendant. And that's how the co-defendant got off. And that's the clearest demonstration of prejudice in my mind. This case should have been tried separately. Clearly, this case should have been tried separately. This case should not have been tried together. And whether I don't know what would have happened with the result, and I can't sit here and say that, but I can say that prejudice was clearly demonstrated in this case, and it was demonstrated by the verdicts. I think everybody was pretty shocked by the verdicts, and I think it was demonstrated clearly by the verdicts. Now, I'm still focusing on the statement of Ms. Mendez. Does anybody want to ask any questions regarding that, or that's clear? Because the next issue I want to go on to is issue number 7, and then end with issue number 8. Issue number 7 is also everybody was allowed, and this was again over objection, to testify to several acts of the defendant that, in my mind, were not related to the incident, and one of them might have been, one of them wasn't. This Miss Bergstrom got to testify that the defendant threatened to kill her and her daughter.
Well, first of all, and I'll ask the Commonwealth this, how was that an admission against interest of Ms. Bergstrom? I didn't understand that. The
I'm not
Commonwealth
sure.
argues in its brief that the statement was an admission against interest. I don't know how it's admission against interest of Ms. Bergstrom.
I agree with you.
I will
I'm not
ask
sure
them
why
that, so
that
that
came.
would cut that out right
There were
away.
several interesting rulings by the judge, I would have to say, and several different interesting instructions to the jurors by the judge that, in my mind, had nothing to do with a lot, and I think were very incorrect instructions. And that's another part of this case that's troubling. But yes, he allows this threat in, and it's not a matter. The threat to kill Bergstrom and the daughter occurred before the incident. So we're not even
So
talking.
in comes, you say, this bad act evidence that this guy's a bad guy because he's going to kill somebody else.
Well, he threatened to kill the witness and his daughter, but he threatened to kill her before the incident. So it's not consciousness of guilt or an intimidation of a witness issue. It's an idle threat that occurred before the incident that has nothing to do with this case. It was objected to. It was a question. She answered it. It was an objection. So I don't know what comes in. And I wrote down the instruction of what
And she was a witness in the sense of what,
she.
in this case?
I think she testified to something fairly innocuous. I think she testified that she heard the shots. I believe so, and that she.
Well, I could see a linkage in the sense that the Commonwealth wanted the evidence if she was an important witness in this case, because it would show there she was in front of the jury, even though she had been threatened by the defendant, telling her story about the incident, and
But she was
therefore was
threatened.
more credible.
But she was threatened before the incident. So it's
No,
not.
I'm just sketching out a theory now.
Well, why doesn't that go to the defendant's intent? I mean, she was threatened because of what?
No evidence why she was threatened. She was threatened. Her.
No evidence about why she was threatened? This is just a so-and-so threatened me? Because why?
There is no.
Because I'm hanging out with your Tony Roma, the intended victim? Is it Tony Roma? Tony Vaughn.
Vaughn.
That's the rib place.
That's right. Tony Vaughn, the
Tony
intended
Vaughn.
victim?
as I sit here, don't remember the linkage of it, but I do know that the threat occurred before the incident in question. So it wasn't, again, it wasn't an intimidation.
But if
type.
it's linked to the defendant's hatred of the intended victim, why isn't that relevant?
But I don't think it is. I mean, I understand your point, but again, if he says I'm going to kill you and her, and it has nothing to do with this case, why does it
I'm
come
going
in?
to kill you because you're hanging out with that guy who, by the way, killed our friend.
I don't believe that's the evidence.
All right. Well,
I know you'll look, but I don't believe that. I don't believe
Okay.
that's the evidence.
Okay.
And I do see a link if it happened that way, but I do not
All right.
believe that that's the evidence.
This is worse than 310 to Yuma. These
Yeah.
people running around shooting at each other.
It is similar.
Well, there's another statement, and I wonder maybe you can help me out on this one. A statement that was admitted of the co-defendant saying that the defendant had robbed someone some other time.
That was next. That was going to be next.
Right,
That's
right, I
issue
understand
8.
that. So, no, my question is, what is the relevance of that? I don't understand. What's that relevant to?
Again, there was an objection. Well, and the interesting thing about that is testified that the co-defendant gets to testify. The co-defendant gets up and says he heard. Now, we don't even know who he heard it from, but he heard that the defendant was involved in a robbery, which is why Huertas got shot. Now, there is a link there, because Huertas is supposedly Scan, who's the one that, the reason why Vaughn shot Scan, and then that's why
This was alleged to be a revenge
a
killing.
revenge
for-
killing. But
All it
got
was
shot the
was
wrong
he
person.
heard? That's all it was?
Yeah.
Not he saw? He knew?
heard. Nobody, see, everybody got to testify about this, quote, motive and this robbery. Nobody saw it. Everybody heard that this is the reason that this occurred. 4 people testified to this. The several of the women in the car testified to this. Well, they know that this is the reason why this was going on. But nobody saw it.
Nobody saw what?
The robbery.
The quote, the robbery that started this with Huertas or Scan, which started this whole process.
Yeah, but it doesn't, why does it matter whether they saw it if they, who did they hear it from?
Right, correct. We don't know.
They heard it from the defendant, they heard it in the presence of the defendant, it was part of the general discussion
Nobody
about
ever
we
said
need
they
to
heard
get
it-
this guy.
Nobody ever said they heard it from the defendant. Nobody ever said it was the defendant was there. And if they heard, it's just out of clear blue. They heard. And again, the judge gives instructions. I invite you to read them. The judge gives instructions that are fairly innocuous and not clear about when the statement you just asked about. I believe the judge's instruction was, well, just take it as an opinion by the co-defendant. I read that and I thought, well, why does the co-defendant get to testify to an opinion that he heard that this happened? It's a 3-line instruction that it was sort of out in left field. I say this respectfully, but I was a little confused by the instruction. And finally, the last issue I just want to go over real quickly is issue number 8, and that's, again, the observation of jurors. Evidently, it was brought to the judge's attention that the jurors saw the defendant in lockup, and it was brought by defense counsel that the door was open, jurors were there, they got to see the defendant in lockup, in whatever state he was in the lockup, and counsel asked 3 times for the judge to conduct an inquiry as to who saw what, and would that change their unbiased and ability to be fair and impartial. First, it was Friday, and the judge says, I'll deal with this Monday. On Monday, the judge forgets, and then the counsel reminds him on Monday and says, you said you were going to do this, and this was after closing and instructions, you haven't done it. And he says, you're right, I'm going to do it. And then there was an issue that intervened. There was some issue that occurred that intervened, and then he forgot about it and never conducted any inquiry whatsoever to determine whether these jurors saw him, what they saw, could they still be fair and impartial. It was brought to the judge's attention twice. He forgot twice.
Was there any evidence during trial that the defendant was in custody?
I would no. I mean, no evidence, all I can
No, I
imagine.
mean, sometimes it comes in for one reason or another. There was a statement of
Made a
jailhouse
statement in
informant,
jail,
or
correct.
for some reason it comes
Not
in.
in this case that I remember. I'll rest the rest of my arguments on the brief. Thank you very much, Your Honors.
Thank you, Mr. Black.
Thank you.
Mr. Kirkman?
Good morning. May it please the Court, my name is Tom Kirkman, and I represent the Commonwealth in this case. The Court has certainly asked a lot of questions about the record, and I'll try to answer those questions. And let me just try to clarify something to put this in a context. The theory of the defendant's motive in this case arose out of revenge, and this is supported by the record. And that's why there are these comments that arise that Shu, the defendant's street name, shot somebody, or robbed somebody, rather. The backdrop is, as it was developed, is that a man named James Huertas had taken a watch, or allegedly taken a watch, from Tony Vaughn. Tony Vaughn allegedly shot Huertas. That was a shooting that was never solved. But it was in the record that there was this reference to Huertas, or Scan is his street name, as it appears in the testimony, was shot. And that as a result of that shooting, Scan, being a friend of
But was
the
there
defendant-
any evidence other than hearsay about this prior robbery?
Well, I don't know that it was hearsay, because the statement Shu robbed somebody wasn't somebody told me Shu robbed somebody. That was never challenged as to whether that was a statement made by the co-defendant, whether the co-defendant was actually present during the robbery. We don't know from this record.
No, but so the co-defendant stated, who's Shu? And who's Shu? Is
Leon
just some other
Stewart
guy?
is Shu.
The defendant.
The
Oh, so the defendant.
defendant.
So well, did the co-defendant testify that the defendant told him
Yes,
about
the
this robbery?
co-defendant
All right, so it's
testified.
admissible.
Well, he didn't say he told him. He simply said he robbed somebody. That means he could have been present during the
But
robbery.
he could
and
have
so-
been.
He could have been, or he could have heard it from
Wait a minute.
someone.
So Stewart's statement is that I robbed somebody.
Well, we don't know
no,
that Stewart
no.
made that statement. What we know is that the co-defendant said Stewart robbed somebody. The co-defendant could have seen it, or he could have heard it.
Now,
We
that
don't know.
That was objected to. That question and answer were objected to.
That's correct.
And then what happened?
That it was allowed to stand, and
Why?
be
Because
to
you can't
to show
guess.
motivation.
But the source of it was never,
No, that wasn't developed. That's correct.
What was the objection? Hearsay or prior bad act? Or
I honestly don't recall what the basis for the objection was. I'd have to look
All
back
right.
at the record.
It makes a difference. It makes a difference.
Well, if it's admissible for other reasons, though.
But
I mean,
how can it be admissible for other reasons unless one establishes what the basis is? If the defendant, Stewart, told the co-defendant, that's a basis. If the co-defendant witnessed it, that's a basis. But if we don't know how the co-defendant knows this, maybe he overheard it from somebody who's not even involved.
he may have.
And then what's the basis of admitting that?
It's still, well,
It's not a joint venture. He's not saying, I participated with Stewart in the robbery.
well, I think that it could be used also to show that joint venture motive.
How?
Well-
It can be used, but how do you get it in?
Well, he simply says it. You're
No,
correct in that he wasn't challenged. We don't know the etiology or the origin of his knowledge.
But you can't get evidence in unless there's a basis to get it in. I mean, I'm just repeating.
Well,
myself.
I think what if I'm hearing you correctly, what you're saying is without a foundation, you can't get it in. Nobody knows why this fellow's, where this knowledge
But
came
then there
from.
was an objection, so then the burden is on the party, you, who's trying to get the evidence in to show why this is admissible.
Right, and I think the argument that I have is that it's admissible to show state of mind, and
But something
also
doesn't come
motivation.
in to show state of mind unless it is otherwise, unless it is admissible. You can't just put in, somebody said something, and that helps show the defendant's state of mind. That doesn't make it admissible.
Well, I don't know what else I can say. He didn't say somebody told me this, so it's not a hearsay objection. He just said he did it. That's what he said.
Okay.
I have another question, since we're talking about statements. The question that I asked the defendant, you say in your brief that the statement of Bergstrom about the defendant threatening to kill her and her daughter, you say this statement was an admission against interest. How was it an admission against interest of the witness Bergstrom?
It wasn't.
It wasn't.
It was
So
not.
that's an error.
What I meant by that was she stated they were no longer friends, and the defendant said he was going to run up in my house and kill me and my daughter. The defendant says, I'm going to run up your house and kill me and my daughter. I meant that as an admission against the defendant's interest.
But that isn't how admission against interest works. It has to be an admission against interest of the speaker.
Well, the defendant said, he's going to kill me.
Okay. Okay, I agree with that, but I'm just, well, okay.
And maybe I'm
And how is that relevant to this case? How did you
Well, the
tie
way
it
that's
into-
relevant is if you look back in the transcript, a little bit earlier than that, on Volume 3, about page 586 or so, the prosecutor starts, or the examiner starts by asking Bergstrom about her relationship with Tony Vaughn and also Mr. Stewart. And she's brought to the point where she says, Tony Vaughn and I are friends. And I spoke with Mr. Stewart earlier on. Then we get to this statement. And Mr. Stewart told me that he was going to run up my house and kill me and my daughter. That goes to show this animus that runs throughout the case, that Tony Vaughn was always the target. I think Mr. Black and I probably agree on this, that Tony Vaughn was the target of this, not the eventual victim, the young woman who was sitting innocently in her car.
So is it clear that in the evidence that the threat was made because Bergstrom was a friend of Tony Vaughn?
That's certainly why it was offered, and that's my argument. It did happen, of course, before the shooting.
Right.
But it goes to show the
How long?
defendant's motivation.
How long before the shooting?
I don't recall, and I don't know that it's in the record as to how long before the shooting.
I think the defense counsel said about a week, but I don't know.
It may have been a little bit longer than that, but I don't recall. I also would like to talk about...
And there was an objection. There was an objection to that, correct?
Fortunately, I don't have a transcript in front of me.
I could check that.
He said there was. Mr. Black said there was. He said there was.
Yeah, well, then he's probably correct. I apologize. Going to the Moran issue, though, because that is the issue that was very hotly contested. It was a large part of the motion for a new trial. And the backdrop to that is defense counsel for Mr. Stewart joined in. He testified he joined in the motion to sever, which co-defendant filed. That motion I appended in my supplemental appendix, as well as the co-defendant's docket showing the filing of that motion. The motion was denied. Now, that's in advance of trial. Then a very unfortunate thing happens. We get to trial, and the co-defendant's counsel stands up to give his opening and says, Hendricks is going to testify, and he's going to say that Stewart did it. And Mr. Redgate, who was Mr. Stewart's lawyer, testified at the motion for a new trial that he was surprised by that because of an off-the-record lobby conference that had occurred. It's off the record. We don't know what was said in the lobby. The judge also immediately reacted and said, as Mr. Black told you, you're skating very close to the line, counsel, or words to that effect with regard to severance. It appears that the trial judge was as surprised as Mr. Stewart's lawyer was.
Mr. Kirkman,
Yes.
I don't mean to interrupt you, but
No,
I
please
looked at the trial judge's explanation as to why he didn't grant a new trial on that basis. And what he seems to he goes through all the case law, and then he says, but here the jury clearly didn't believe there was a joint venture. They believed that only one person did it. Doesn't that, in essence, beg the question. I mean,
It does.
They
It does beg
so
the
the motion,
question.
so the decision. I mean, it's very helpful to have a trial judge explain why a new trial shouldn't be given, but that one just didn't help. me.
I would agree with the court. And
Well, okay, so everybody's surprised at this point, the judge, the defense lawyer, and so on. Why didn't he sever at that point?
perhaps he didn't feel that I mean, I can't speak for the judge,
I mean, did the
obviously.
defense lawyer
But
say,
perhaps
"Oh,
he didn't feel that the cases were mutually antagonistic at that point.
More important, and this is the second time this week I've unfortunately had to ask you this question, Mr. Kirkman, why didn't the prosecutor at that point say, Judge, this sounds like, we better have a hearing on severance right now?
Well, I think the answer to that is that the prosecutor wanted to move ahead with the joint liability theory.
That's fine.
Well,
But what I'm suggesting is, because this is the second time this week we've had, and I don't mean to be unfair to the prosecutor in either case, but we've had serious cases from your office where there are problems that we don't have to have. If people would think that it isn't just a conviction, the conviction has to be affirmed on appeal.
I think this case is a little bit different perhaps than the argument that we had earlier in the week.
All right.
In that, in this case, severance wasn't warranted. It simply wasn't, and we know that from hindsight. And
Because?
at that
Because the
point-
because you heard right in the opening statement, didn't everybody hear in the opening statement the co-defendant say that
Say he's
they
gonna
were
do
going
it,
to
but they
blame the
also-
defendant?
They also had heard that this witness, this witness, this witness, and this witness were going to put the defendant at the scene, that he was a shooter.
That doesn't
these bullets were
matter.
fired.
I don't think that matters under Moran. If the co-defendant is, if there are two people and one, and the way out is for one of them to blame the other one.
I don't think that, I disagree with the court, and I don't think that's the end of the
Was the
discussion under
co-defendant
Moran.
at the scene of the shooting?
I'm
Yes,
sorry?
they
Yes,
both-
he was.
Yes,
both-
he was, and so therefore, he could have been there to help and assist, so he was a true joint venturer.
That's correct.
That's correct, that's why he was tried.
That's exactly why he was tried.
So
And-
therefore, putting the blame all on the defendant is a classic severance situation,
Well,
even though there was all this evidence that the defendant was the shooter.
but I would agree with the court if there was only that evidence and none of the other evidence.
How many? Did the bullets all come from one gun?
Yes.
It's not clear. The bullet that was found in the victim's brain could have come from a 25 millimeter or 9 millimeter. They resemble each other on
No, but
impact.
were there other bullets around? Was there any one casing discovered, or one bullet?
I honestly don't recall, because there were so many bullets that were fired. I would believe that they would show two guns. Certainly the witnesses said there were two shooters, and there were multiple shots in the house, in bushes. Dina Bergstrom, who was inside the house, heard the gunshots. She's the one that called the police, by
But
the
only
way.
one gun was recovered.
One gun was recovered, that
And
is
the
correct.
co-defendant testified that he didn't have a gun.
Right,
That's why
but
I
the
asked
other
what
people in
the-
the car said that he did.
So the question is ballistics. Was there any evidence that they came from two guns?
I honestly don't know, without taking a closer look at the record. I don't recall that, because in preparing my argument, I was looking at the culpability of this defendant, because I think it's that culpability that, like in Senate and the other cases that I've cited, that avoid the severance problem at this stage.
You mean it's premature? You mean it's when they made
Well,
this-
I'm sorry.
Well,
to
no,
interrupt
go
you.
ahead.
What I mean is that because of the positive evidence linking the defendant to the murder that is independent of his co-defendants taking the stand and saying he did it, that positive evidence gets us out of the Moran issue. Moran was a case where there's really only two people, and it's one or the other.
But it's the
We've
same
got-
here. There's really only two people, and one or the other shot the gun.
Well, I understand that, but that's also arisen in other cases this Court has decided that I've cited in my brief with regard to other eyewitness evidence. And what it gets to, what it seems to me anyway, what's really at heart here is, was the jury improperly misled in its verdict, and misled meaning finding this defendant guilty when it probably shouldn't have because of the severance problem.
Well, how does this defendant combat the co-defendant's statement that this defendant shot the victim without this defendant taking the stand and denying it?
Well, he can't. He would have to simply get to that stage. The theory of the defense was that you couldn't tell who the shooter was because these other eyewitnesses said there were two. Although one put a gun, the 9mm that the defendant led the police to later on and said, oh, here's a gun. And that gun happened to match up with the bullet that was
So
found
what was
in the brain.
his defense? That he didn't do it, the other guy did it?
His defense, as articulated by counsel during the motion for the new trial, was that you don't know who the shooter is, so therefore you don't know what the intent was, and my client's not guilty if you can't show his intent and that he was the shooter. We don't know who the shooter was.
Okay, so he is implying that the other guy was the shooter. In which case, you got them blaming each other in effect. Which
Well,
is a severance
essentially,
problem.
isn't the question that the Commonwealth theory is joint venture?
Joint and individual liability. The prosecutor was very clear about that in his opening and his closing.
Well,
That the
really-
jury could find joint venture and should, but also that there is individual liability.
On each of the defendants?
That was the
So
theory.
that doesn't help you much either, in my opinion, the individual part.
Isn't it, if you have a defense of, you can't tell who the shooter is, isn't it pretty darn prejudicial to have one of those shooters stand up and say it's the other one?
There's no question it wasn't. It was prejudicial to Mr. Stewart's case to have his co-defendant take the stand and say he pulled the trigger in much the same way as if they had some other witness say it was him, and it wasn't him.
But there wasn't.
Well, it seems to me that when that co-defendant counsel made that statement in the opening statement, the prosecutor's ears just should have gone up, and there should have been a hearing right then and there out of the presence of the jury about whether this was going to require a severance. It's only the beginning of the trial, the opening statement. I mean, it doesn't matter when it is, but it was
Well, I
fortuitous that
certainly
it was right at the beginning.
And that wasn't done. And the judge moved forward with the trial.
Could you tell me a little bit more about the finding of the gun? The defendant led the police to the gun,
Yes.
and that was the gun that actually fired the bullet that killed the woman.
As positively as ballistics could make it to be, yes. It was a 9mm weapon. The bullet that was found in her brain, again, this was developed in the record by our ballistics expert, was a jacketed bullet that could have come from a 9mm gun. It might have also, as I recall the record, come from a 25mm, but it was enough of a linkage. They did find other 9mm shells at the scene because there were shots into a house and a window frame, and it was as the one witness described it, it was a spray type of
They
shooting.
couldn't match the bullet.
Well, no, because of the
specifically-
compact. That's correct. Again, it's my recollection of the record, and that may be inaccurate, but that because of the impact of that bullet going into the young woman's skull
Okay.
and being compressed.
And what were the circumstances under which the defendant led the police to the gun?
Well, the police interviewed him, and the officer testified that he then took us out to this wooded area where other witnesses, the driver, had said, I stopped. These fellows got out of the car with the towel, wiped off the guns, and they deposited them in the woods. And the defendant took the police, according to the officer's statement, to the wooded area, and they found the gun. And that's a very strong admission by the defendant, along with certainly his post-mortem statements or post-shooting statements over the cell phone to a witness named Frank Avant. Mr. Avant testified about the defendant's statements to him that me and my co-defendant just shot Tony Vaughn, and words to that effect. I mean, there were colloquial expressions and swears used.
Yes.
Yes.
Excuse me, Mr. Kirkman. Was only one gun recovered?
Yes.
Because the driver of the witness who originally led the police to the area said that she saw 2 guns being wiped off?
That's correct. Oh, and I don't, obviously we don't know what happened to the second gun.
Okay.
I've got about 13 seconds left. If there are no further questions, then I would rest on my...
Thank you, Mr. Kirk.
Thank you very much.